Good evening, everyone, and welcome to the town's Property Standards and Animal Services Appeal Committee meeting this evening. My name is Jessica Black, and I am the chair of this committee. I'd ask everyone with an electronic device to turn it off or to silent so as not to disturb this meeting tonight. It is now 7:01, and I'd like to call this meeting to order. To begin, I'd like to read the Town of Ajax's land acknowledgement. We acknowledge that the land on which we gather is situated within the traditional and treaty territory of the Mississaugas, more specifically the Mississaugas of Scugog Island First Nation, signatories of the Gunshot Treaty of 1788 and the Williams Treaties of 1923. This land is and will continue to be home to the Indigenous peoples. Let us acknowledge the mistakes and traumas of the past with authenticity and support truth and reconciliation. Let us engage and celebrate Indigenous communities by leaders of action, or by being leaders of action, acknowledging the United Nations Declaration on the Rights of Indigenous Peoples and the Truth and Reconciliation Commission of Canada's recommendations towards truth and reconciliation. Let us keep these principles close as we continue towards truth and reconciliation and move forward with kindness and respect as a community. Thank you. I will now give a brief overview of the committee's role and the process in which we will move through these proceedings this evening. The Town of Ajax Property Standards Committee has full delegation of the authority in the Building Code Act and the Municipal Act to hear appeals from both property owners and dog owners who disagree with the served property standards order or an order to restrain and make decisions on these appeals. The committee shall hear evidence presented by witnesses, town bylaw staff, and property owners, and any other individuals that may have evidence relating to the matter before the committee. If an appellant or the town disagrees with the decision of this committee pursuant to a property standards order, the appellant may appeal to the Superior Court of Justice within 14 days of the committee's decision being sent. If an appellant disagrees with the decision of this committee with pursuant to an order to restrain, the appellant may appeal to the town's General Government Committee within 14 days of the committee's decision being sent and paying appropriate fees. This process will be outlined in the written decision that will be mailed to you after this meeting. Town staff will present their testimony to the committee. The committee will then ask the officer questions. At the conclusion of the committee questions, the appellant will then have the option to ask questions of the town. This is only an opportunity for questions from the appellant and not for providing statements to the committee. This process will continue for each witness that will give testimony on behalf of the town. At this point, the appellant will present their testimony to the committee. The committee will then ask the appellant questions. At the conclusion of committee questions, the town staff will then have the option to ask questions of the appellant. This process will continue for each witness that will give testimony on behalf of the appellant. I will then ask each side to summarize their respective positions, starting with town staff. At this point, the committee will then deliberate. Town staff and the appellant should remain present in the event that any additional questions are raised by any member that requires clarification. At the conclusion of our deliberations and decision, I will verbally notify the appellant of the committee's decision with regard to the appeal and remind you that you will receive the committee's decision in writing. Thank you. Item number 2 on our agenda is the minutes from our previous meeting. Does any member have any questions or comments regarding the minutes?
It mentions that I was both present and absent. I was in fact present, so can we amend that?
We will.
Thank you. Do I have a motion to accept the amended minutes?
I accept.
Thank you.
Minutes.
Are we showing hands? Oh, electronic. Perfect. Thank you. Thank you. Now we're going to continue with the agenda here. Item number 4, 4.1, is the appellant Ra Wasmund here tonight? Thank you. Okay, at this time, the town staff will have their opportunity to provide testimony.
Understood. Thank you.
Thank you. Good evening, members of the committee. My name is John Pappas. I'm legal counsel for the town, and I'll be making submissions on behalf of the town today. The property standards officer that issued this order, Officer Kaylee Farrell, is unavailable to attend this evening, and in lieu of her attendance, she's provided a synopsis of her evidence, as well as photographs that appear in the appeal package. I'll provide an overview before I make my submissions with reference to the appeal package and the agenda package before you. Where I do refer to a document or something that's in the appeal package, I'll call up a page number, and I understand that that'll be displayed on the screen for the benefit of the members. So by way of overview, this case is about the placement of construction materials on a property that is no longer an active construction site. It's causing an unsightly condition in the neighborhood that's out of character with the surrounding area. And there have been numerous complaints from local residents about these issues. That's precisely what the town's property standards bylaw seeks to prevent and is intended to address. And that's why an order was issued. The subject property, the property that's subject of the property standards order that we're discussing tonight is 487 Poplar Avenue, and that's in the Pickering Beach area of the town. The site's currently improved with a one-story dwelling, a single detached dwelling, and the property owner is seeking to construct an addition to the rear of that property. And the site has been under some phase of construction since 2016 when a building permit was issued. Building permit was first issued in May of 2016, and the property owner also previously had a building permit for the rear addition that was issued in October of 2023. That building permit has since been revoked by the chief building official, and that decision was made January 3rd of this year. The property owner appealed that decision under Section 25 of the Building Code Act to the Ontario Superior Court of Justice, and did so on January 30th of this year. The hearing for that appeal has not yet been scheduled. No timeline for the exchange of materials has been set, and at this point, the town does not even know when that matter will be in a position to be scheduled for a hearing. So that's the background for the order that's been issued. The site is no longer an active construction site, yet there are construction materials staged on this property. They need to be cleaned up, and that's the town's position, and that's why the town issued the order it did. The town's position in this appeal is that the order should be confirmed. So as I mentioned, in lieu of Officer Farrell's attendance tonight, she's provided a synopsis of her evidence that's up on the screen right now. So in May of this year, Bylaw Services determined it was necessary to conduct a property standards inspection of the site based on several complaints that were made by local area residents about the state and condition of the property. So that inspection was undertaken on May 23rd, 2025. And reading from the synopsis in the second paragraph, what the officer says is, I inspected the property and observed a residential dwelling with significant development/construction enhancement projects that appear partially complete. On the property, I observed quantities of construction material, including I-beams, rebar, machinery, and other equipment stored on the north side of the property. See attached. And what she's referring to in her notes are the photographs that have been attached to the synopsis, which I'd like to take the committee to now. And that would be page 16 of the appeal package, or pardon me, the agenda package. So this is a first photo. This is a view of the front of the building looking from Poplar Avenue. And what you can see in this photo are steel I-beams that have been stacked in front of the house in the front yard. There's construction fencing behind. Further behind that, there is the existing dwelling unit that doesn't have siding. It's partially wrapped with Tyvek vapor barrier. I'm not certain if it's visible on my screen, but if the members look to the top left of the stack of I-beams, there's an excavator that's parked on the site. And this is just the front of the property. If we move on to the next photo on the following page, there's another view of the front of the property. And again, we see the same steel I-beams stacked. And moving on forward to the next photo. This is a photo of the rear of the property where forming for the foundation is laid out. Moving on forward. This is a view looking from the back of the property toward the dwelling on the property, and this is inside the foundation, what will be the foundation of the building. And again, this is another view looking further back on the property toward the back of the dwelling on the property, where there's open excavation. And again, construction materials in the foundation, the open excavation. And we can continue on to the next photo. Again, the forming for the concrete foundations. We can go to the next photo as well. This is the side of the property, the side of the house. We see materials that are stacked and accumulated on the property. And in the next photo, the very last photo, we see rebar stacked by the forming for the concrete foundation. So this is what the officer observed on her May 23rd, 2025 attendance on the property. But it's important, I think, to give the committee an understanding of where these materials came from. I don't think it's disputed, or it's certainly not contested, that these materials were intended to be incorporated within the building that was intended to be constructed on this property. They were previously stored at another property down the street that is under related ownership with the current property owner and the appellant, and that's property on Rangeline Road. That property was the subject of a consent to sever, so it was formerly a larger lot that was severed into 3 smaller lots. And as a result of that, under the town's zoning bylaw, outdoor storage of materials and equipment was not allowed on those lands because there was no associated building or structure. And so the town sent a letter to the property owner, and that's in the agenda package at page 42, if we could skip forward to that page just momentarily. So a letter was sent to the property owners of that Rangeline Road property advising that storage of materials did not comply with the town's zoning bylaw and requiring that those materials be removed from that property. Below the, pardon me, if we could scroll up just a little bit, below the bolded paragraph, so this is the 4th paragraph in the overall letter, the town advised that it would be conducting a reinspection and also noted that there was a way to achieve compliance. And it noted that compliance could be achieved by storing those materials on a property that did have a dwelling unit in conjunction with, or in accordance with, the requirements of the property standards bylaw. And if we can move forward 2 pages to page 44. So this letter was sent on January 28th, and on January 31st, all of this year, a discussion took place between the town and the property owner about how to achieve compliance with the zoning bylaw. And that discussion resulted in an email from Officer Farrell on January 31st, where the officer indicated that these materials could be moved to the Poplar Avenue site. And as you heard me mention, the building permit at this time had been revoked, and that decision had just 1 day prior to this email been appealed to the Superior Court of Justice. So this had just been started. And what the officer said was, in the first 2 lines, that there wouldn't have been an issue with storing these materials there in the short term. And I emphasize in the short term because at this time, the appeal had just been commenced, and it was anticipated that it would be dealt with. So that's the history of where these materials came from, what the current condition of the site is. And I'd like to take the committee very quickly to the order that's been appealed. And that's at PDF page 27. So the committee is no doubt familiar with the structure of these orders. So Schedule A is where the specific requirements and details of the order are found. The order essentially requires 2 things to be done on the property. The first is the removal of all construction equipment. So this is heavy machinery, excavators. And the second is the removal of all construction materials. So this is the I-beams that I took you to in the photos, the rebar, and other materials that are stockpiled on the site. And that's because this engages a number of provisions of the property standards bylaw. I don't mean to be exhaustive in my review, the committee members have it, but the few provisions I would like to take the committee to are section 4.2 of the bylaw. If we could scroll down on that page just a little bit so that it's in the center. What section 4.2 of the bylaw provides is that dilapidated, collapsed, or unfinished structures and all accumulations of materials, wood, debris, garbage, and other objects that create an unsafe or unsightly condition out of character of the surrounding environment shall be removed. And I'll remind the committee, the surrounding character of this area is a residential neighborhood. It's a low-rise residential neighborhood. The second provision is 4.10, dealing with domestic storage. And what 4.10 provides is domestic storage shall not be permitted in the front yard. Nothing can be stored in the front yard. And lastly, 4.11, domestic storage has limitations on it. There are numerical limitations imposed on it, but any storage is subject to the remaining provisions of the property standards bylaw. And so that's the order that's been issued, members of the committee, and that's the basis on which the officer issued her order. And there are a few points that I'd like to address about the order and the appellant's arguments, which you'll hear from the appellant shortly about these arguments. But the crux of the appellant's arguments for rescinding the order or modifying the order is twofold. First deals with previous enforcement direction, and the second deals with fairness with the pending building permit appeal. So the first alludes to the letter and the emails that I'd just taken the committee to, dealing with the storage of the materials contravening the zoning bylaw at a different property and the relocation of those materials. And what I expect you'll hear from the appellant is that the town previously said storing materials on Poplar Avenue is fine. But that's wrong for two reasons. I've taken you through the context of why that representation was made in that January 31st email. That does not deal with the property standards bylaw. That deals with a zoning infraction on another property and a solution to that property or that issue in the short term. The officer allowed temporary storage in the short term as a means to satisfy the zoning issue on site because it was anticipated that the building permit appeal would be resolved quickly. And it won't be. We're here in July now, almost in August, and a hearing date has not even been scheduled for that appeal. And in any event, that email doesn't grant a variation from the property standards bylaw. It can't. Staff simply can't grant a minor variance or deviation from the property standards bylaw. That applies town-wide. And in the letter, which I'd like to bring up just one more time at page 42 of the appeal package, in the fourth paragraph, so that's the paragraph just below the bolded paragraph, third line down, just halfway across the page, what the officer says in that letter expressly engages the property standards bylaw, that the storage must be, in her words, in conjunction with, what I'll say is in compliance with, the property standards bylaw. So this was raised with the property owner. So that's the first issue. And the second issue I'd like to touch on is the overall fairness of the order pending the outstanding appeal of the revocation decision. Nothing about the order is irreparable. It's not as though the order requires the property owner, I should say, sorry, to demolish the house or to remove the partial construction. The order doesn't even require him to abandon these construction materials. All that's being asked of the property owner is to remove them from that property. These construction materials can still be used pending the outcome of the appeal or used on a different project at a different site. But nothing about the order is something that can't be undone in the future. And that's why in my submission the order is fair and reasonable. Because ultimately that has to be balanced against what the community's expectation is, which manifests through the rules that are set by council in the property standards bylaw. And where I'll end with that is a reference to the property standards bylaw at PDF page 28. That's section 3.4 of the bylaw, as included in the order. The owner of any property which does not conform with the standards of the bylaw shall repair and maintain such property to conform with those standards. And that's precisely why this order has been issued. So subject to any questions from the committee, those are my submissions on behalf of the town.
Thank you very much. Now is an opportunity for the committee to ask questions. Okay, the committee doesn't have any questions. Now is the opportunity for the appellant to ask questions of the town. I just want to remind you that this isn't time for your testimony, it's specifically questions. You'll have a chance in a moment to give your testimony.
Okay, so my question to the committee right now is, well, I really don't have any. The entire operation of what we've been facing for the past 9 years.
Okay, do you have any questions for the town specifically?
Yes, I do. I want to know if this is directed towards the town, if everybody can take a page, look at 97. I received a letter from Mr. Clayton Wheeler to discontinue all site work and attend the town hall. Now, if I flip over, that was with regards to applying for a site plan application. Take a page, look at page 101, the site plan application was prosecuted against for not having a site plan application. So I put together a site plan application, and I submitted it to the town of Ajax.
Sorry,
The
sir.
question is coming, Ms. Black. Now, if we want to take a look here at page 106 from the CBO. After a 4-year delay, the question I have for the town is, why did we need a site plan application if the CBO states right in here before revoking the permit the first time, after we attained one, that we didn't? Mr. Pappas?
Thank you. I don't know if I'm in a position to clarify what the CBO has said out in his letter. I think his word speaks for himself. That permit, the 2016 building permit, was for a front porch addition. And based on the Planning Act, there's a definition of development which is captured within a site plan, when a site plan is required. And perhaps it was his interpretation at the time that that front porch addition did not require a site plan, although one would be required for the overall development of the site. I'll also note for the committee that the law in this regard did change in 2022. Previously, the definition of development would apply to one single residential building being constructed on a lot. That's no longer the case. There's an exemption for developments of 10 or fewer residential units.
Mr. Pappas, that isn't true. In 2015 and
Okay,
16, the
sorry,
permit
sir,
application was for the
I'm just going to
front.
interrupt you here.
Yes, Ms. Black?
We're asking questions related to the town's testimony. The testimony that was provided by the town didn't address any site plan issues.
I understand that, but in order for us to understand the scope of the 9-year delays that we're facing and the current ongoing issues we're having with the site, it's good to have a good grasp of everything that's happened in the past. If we don't establish the grounds, we don't establish any of my testimonies today.
Okay, I will ask you to provide your testimony if you have no specific questions for the town based on the testimony that was provided.
As of right now, the only testimony I have is that we have pictures from today. Ms. Farrell had indicated that she would take some prior to the meeting. I don't see any pictures that are more recent than the ones that were taken. These are updated ones. I have 15 copies here, enough for everybody on council if you want to take a look. This is what the site looks like today. It has been cleaned up since Ms. Farrell's visit back in May. And I mean, we're holding it hopefully for the appeal process.
I'll ask the committee if we have interest in seeing the photos from today. Okay. You can stay there, sir?
Yep. If you can just take a recess, we'll make copies.
Yeah, we'll take a brief recess for copies. Okay.
For those people joining us electronically, do you want me to forward a copy email-wise? Okay. just for the
Does the town need to scan the pictures in before we continue? We're okay? Thank you. Okay, sir, thank you. Please, now is your time for testimony.
Thank you, Ms. Black. So in these pictures here, the ones that we took here just hours before the meeting, the larger machinery has been moved from the site, and the beams that were originally in the driveway zoneway have been placed to the side area where the rear excavation is. The galvanized steel beams on the front porch have remained up on top of the front decking, only because logistically it's very hard for us to move them out of there. We need a crane. And they're actually designed to go on top of the rear addition zone when it gets to the point of flooring, which we're hoping, if our resolution with the town is anytime soon, that we're able to get back underway. The back end of the property, there is a mini excavator. Now, this is a very small unit, but the size of a golf cart. It's remaining on site only because it has to do site stability checks. Once a week, we have to grade and pull back the upper zone laneway because when it rains, we have some landsliding happening there. Again, this material was staged temporarily, but now it's been 7 months since the revocation, and that's why that little machine's in place. The little machine is very quiet. It's no louder than an air conditioner, and it's, like I said, the size of a golf cart. And again, it's site maintenance. The rest of the site has been tarped, and the tubing and hydronic systems have all been sheathed so they're not exposed and standing, the ones that are on the edge of the property. And there is a security fence and, of course, all the silt fencing in place. And that has been in place since the operation began. I'm simply asking that we can maybe have an allowance to maintain what we currently have while we are seeking to have the site or the building permit reinstated.
Does this conclude your testimony? Okay, now is the opportunity for the committee to ask questions of the appellant. Does anyone on the committee have any questions? Sure, I'll give you a few more minutes.
So quick question here is, as per the order, the way it's written, it talks about all machinery, like the excavators, should be removed from the property. Is there not a better way to store that mini excavator that you have there, such that it is actually in line with the order?
What I can do, if permitted, we can move it into the lower back basement zone of the existing renovation area. There is a ramp in the back that we had situated in such a way that we had access because of the size of the residential addition. We can drive it down there, but the only problem is that during the rain, and we've had some pretty big deluges in the area at the time, it's hard to get back up the ramp with that little machine. But I mean, if I have to, I can put it in there. We can try a different way to maintain the laneway.
Okay, thank you.
Are there any other questions for the appellant?
Sorry, I apologize. This is out of order, out of turn, but maybe it's not to the appellant. But have the actions taken been enough to satisfy the requirements of the order? Some material has been removed from the front. Some material has been removed from the sides and into the opening in the basement. Is that enough to satisfy this order?
I think we do need to deliberate on that. But if you have any specific questions for the appellant.
I do not have any questions for the appellant. Thank you.
Now is an opportunity for the town staff to ask questions of the appellant.
Thank you, Chair Black. I only have one question of clarification. Well, I'm looking at page 1 of 5 of the photo booklet that was provided by the appellant, and in the lower left-hand quadrant, there's a photo of the front of the property looking for Poplar Avenue. Can the appellant clarify what is under that blue tarp in the photo?
Yes, as I stated, it's the galvanized steel posts that are up on top of the front deck. They're the ones for the upper deck area. They're the ones that are lifted in place by the crane.
Thank you. I have no further questions.
Okay, thank you. Now is an opportunity for each side to summarize their position. So I will ask the town to start with their summary, and then I'll come back to the appellant. Thank you.
Thank you, Chair Black and members of the committee. For the reasons I outlined in my earlier submissions, the order should be confirmed as is. And if the appellant is seeking some period of time to comply, an extension from this committee, that would be acceptable to the town, provided that the length of that extension aligns with the length of the delay between the order's compliance date and today's hearing. So 3 weeks is initially provided for in the order. But the committee has been taken through in my submissions and in the evidence synopsis and the photos that are included in the agenda package is very clear that there are a number of instances of nonconformity with the property standards bylaw. And even as recently as today, we still see storage in the front yard. We still see rebar and I-beams on the site, and we still see an excavator on the site. And that's not acceptable, and that does not comply with the order. And those are all my my submissions.
Okay, thank you. The appellant, do you wish to summarize your position?
Yes, Ms. Black, thank you. The rebar that we're looking at in the pictures, they're actually located in the lower basement area, the addition in the rear. They're not visible from the roadway. And the steel beams that are alongside the main sunroom zone of the new addition, those are in the side yards where Mrs. Farrell had indicated that she wanted the I-beams. So everything has been moved into place as per her original recommendations for us, and the large machine has been removed. And as per the council, I can make an effort to have the little machine removed so you don't see it from the laneway as well. And the galvanized steel poles, if you would like, we can get the crane back in and lower those to the back into the basement area, so they won't be staged in the front. The only reason they were there is because they will have to come back out again once we get back underway. I mean, I'm very accommodating for that if we can. Initially, when Mrs. Farrell was there, or Ms. Farrell, sorry, was there, I thought she wanted us to move the site material in the rear of the property. That was difficult for us to do. But if it's just for this here, we can definitely make the adjustment to move those galvanized beams.
Okay, thank you very much. Now is an opportunity for the committee to deliberate. So I would ask that you both remain. We may have questions for either of you. So please remain. You can have a seat, and we'll deliberate.
I guess my only question, since he is willing to move stuff, I think the order is pretty well stated, and the stuff should get moved into that basement area. Just would depend on how much time he needs.
Yeah, I agree. From the photo, the more recent photos, to me, that's all kind of qualifies as construction materials and machinery, which I think should be removed, and I don't think that would qualify to be moved to the back of the property either. Given how much material it is, I do think probably a time allowance would be required. Whether that be 3 weeks or a month, I think would be reasonable.
It's the galvanized steel. I'd like to see that moved from the front of the house. That was one of the requirements, and one thing that does bring down the appearance of the property, appearance of the neighborhood. So if that were to be moved off the property, I don't know if putting it within the confines of the new build part would satisfy the town, but that definitely needs to be moved from the front of the house.
And what's your stance on the excavator and other items in the backyard?
Sorry, as stated, the excavator would need to be moved from the property.
Yeah, I'd like to say that, you know, efforts have been made so far, and therefore allowing more time to actually uphold the order as written would be my recommendation.
I do have a question for the appellant. Sir, if you can come forward, please. My question is in terms of obtaining a crane to remove the large beams at the front of the property. What sort of a time frame would you need to get a crane in to move those beams?
It depends on what the move is. If we're moving them into the back lower quadrant, it would take about 2 weeks. If it's to move them completely off-site, it's probably going to take us 2 weeks plus time to find a location to store them.
So possibly an additional 2 weeks.
With a month, if we could, that would be perfect.
Thank you. Thank you. You may sit down.
Thank you.
Okay. Looking at the information provided, the evidence from the town as well as from the appellant, I agree that there have been some efforts made to clean up, but it does appear that this is still contravening the bylaw as written. And I'm not sure that the open excavated area of the property, which is the future basement, would be considered inside of a dwelling or a location that would be not visible and a danger on the site. So my thoughts are in terms of my colleague here with regards to extending some time for the removal.
Sorry, and just for clarification, it wouldn't be removal just from the front of the house, removal from the property in its entirety? Those I-beams, sorry, those galvanized steel beams. Yeah. Other than that, I think a lot of work has been done. It does look better than before, much improved.
Yeah, I would say with, like, uphold the order as written, with an extension of time to the month or 4 weeks that was requested.
Okay, so we have a motion to uphold the order as written with one amendment in terms of the time frame to allow for the order to be upheld as written for a 4-week period.
Correct.
Okay, so you've put forth the motion. Does perhaps we want to vote on that?
Where's that?
Should be anything.
Okay, so the motion is upheld. Okay, so for the appellant, the committee has deliberated. The bylaw motion, the order, has been upheld with a 4-week extension to come into compliance with it.
Excellent, Ms. Black, thank you. And just for my general knowledge here, this is regarding just the beams and the machinery, correct?
No, this is the entire order as written.
The order is not clear, where it's talking about the beams and the machinery, correct?
All the construction material and debris. So the
So it's a four,
yeah, it's the 4 bolded items that were
On page 28,
On page,
sorry, 28.
Yeah,
on
page 28.
page 20. 28? Yes, no. Yes,
the
Schedule
Schedule
A. My apologies, Schedule A. So the property standards order as written has been upheld with a 4-week extension for you to come into compliance with it.
Okay, and this is based on the materials we spoke of tonight. That highlights the galvanized, the I-beams, and the machinery.
The entire order as written.
I would need clarification on the order then.
So that the property is maintained free of debris, that all construction material on the property, including but not limited to I-beams, rebar, and other construction equipment, all construction vehicles and machinery on the property, example, the excavators, and any accumulations of material that may create an unsafe or unsightly condition out of character with the surrounding environment. So the I-beams, rebar, and other material.
What does other material mean? Just so I have full clarification.
The other construction material that is not affixed to the house. That is part of the property, sir.
Okay, so, all right. Thank you.
Thank you. Okay, we will move on to the item number 5 on the agenda.
As a verbal update regarding Macro 5 Redmond was a an animal services order that was issued. It was modified by the committee. Re-inspections have proven that the order is now being complied with, and the matter was closed by the town, and there's been no reoccurrence. In relation to 5.2.1, the Weenan 28 Linton appeal, that matter is still open and ongoing and has developed in further actions taken by the town regarding that property. And that concludes my verbal updates.
Thank you. Section number 6, new business.
The town has no new business at this time.
Thank you. So we're moving on to item number 7 for the adjournment. Do we have a motion to adjourn? Perfect. Thank you. And this concludes our meeting.